Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures approximately $10 billion annually. Today, we have the amazing Patrick oh my goodness, Patrick, we're gonna have to thank God we're recording this, but I'm gonna have to have someone edit this. Edgerton, there we go, who is an expert in construction lien law and absolutely incredible. So without further ado, we are going to have Patrick discuss what happens after I record my lien. How do I get paid? So the show is all yours now, Patrick.
Thank you for having me again, Ariella, and I'm always honored to be here giving presentations. I always enjoy it, and I miss the in-person interaction, but this is the kind of the new age we're in. So in this seminar, we're going to talk about some highlights. We do it in 20 minutes. My outlines are generally kind of thorough because some people like to use it as a outline for litigation. Most of my seminars are given to lawyers and judges, but I think it's also helpful to have other persons like contractors and subcontractors and other material providers know these things because it helps them understand what they need to do. First of all, I cannot believe the number of clients who think that because they perfected a mechanic's lien, they are now going to get paid, meaning it's somehow automatic. It is not. It's just merely a lien on the property that might make it more difficult for a property owner to sell or refinance. Ironically, it doesn't stop a property owner from selling or refinancing. Keep that in mind. They can always do a TI account in the title company and put usually 1.5 times the amount of the lien, and it will still close. Or there's actually a new bonding requirement or bonding that is now permitted where you have to do certain things to bond over the lien claim, and that's also then can be sold or refinanced without consequence. But you're protected because there's going to be money there if you win. So what must you do after you do the lien? To maintain your lien rights, a contractor has to file, and subcontractors have to file suit within 2 years of the completion date for all private mechanics liens, otherwise the lien lapses. Keep that in mind. It's the completion date that controls, not the recording date. Some people think it's 2 years from the recording date. If you file within 2 years of the recording date, and then it finds out your completion date was prior to that, then you would be knocked out on your lien rights. Keep in mind that even though the Mechanics Lien Act does not require you to list the completion date in your claim for lien that you record, there is a split in the districts in Illinois that talk about if you have to include it. The first district says yes, you have to put your last date you did substantial work or completion date in the claim for lien. That's the Merchants Environment case. And if you don't list it, then the lien can be knocked out. Now, the second district has ruled that the Mechanics Lien Act doesn't state it, so you're not required to put it in there. We recommend that you put it in, but you have to file within the 2 years. Exception, if you get something called a Section 34 demand, certified mail, return receipt requested, or personally served on you, you have to file suit within 30 days. If not, you will likewise be out. So keep that in mind. Generally 2 years from completion date or last day you did substantial work, or within 30 days of receipt of a Section 30 demand. One thing that people call me is what happens after the 2 years. Well, like if a property owner calls me and I ask them, would you plan on selling or refinancing within 2 years? And they say no, I tell them to ignore it. So you got to keep in mind to watch it and at least 30 to 60 days file suit to make sure you get all the necessary parties named. Waiting until the last minute can be problematic. If you not name all the necessary parties, your lien claim can also be knocked out. Necessary parties are obviously the owner, and then the mortgage companies, and any other person on title who has an interest in the property. So if you wait too long and you miss one of those, you'll also be knocked out. There's something called a knowingly permitted exception. Or sometimes subcontractors, I'm sorry, let's back up. Sometimes subcontractors think they can directly go after a property owner even if the lien is knocked out, under those equitable theories of unjust enrichment and quantum meruit. Those are the equitable theories that say, well, you don't really quite have a contract with anybody, or at least with the owner, but they were enriched by your work. Therefore, I should be allowed to sue them. The courts have overwhelmingly ruled that for a subcontractor who's not in privity of contract with the owner, you have no quantum merit or unjust enrichment rights as against the owner. Your only rights are through the Mechanics Lien Act. So don't think that just because there's a theory out there of quantum merit unjust enrichment and you don't perfect your lien properly, that you can still name a property owner. That is not accurate to do that. So sorry about that. I keep forgetting to move forward. That's what I'm talking about, to seek the quantum merit. So your exclusive remedy is against the owner. It's under the Mechanics Lien Act. You'll still have your contract action against your immediate contractor, either the general contractor or the subcontractor if you're a sub-sub. But don't think you can get away with unjust enrichment against the owner without being in privative contract with them. Now, the nice thing about that is I sometimes, when I file suit for my clients as subcontractors to enforce a Mechanics lien count against the owner and their interests, owners try to file counterclaims for breach of contract or against my subcontractors. Well, it's good for the goose, it's good for the gander. If you cannot file a direct action other than the Mechanics lien against the owner can't file one against you for breach of contract. So, because again, they are in lack of privity. Now, there might be some sort of negligence tort claim, but for pure contract actions, they cannot do that. So there was a theory where the first district tried to get away around it under the implied warranty of habitability, where where they overruled. It's the Minton Richards group case we were talking about, and then there was another case after that where the courts were basically finding that if the owners are having a lot of problems with the property, they would sue the general for implied warranty of habitability or breach of it. And if you could prove that the general was out of business or didn't have the funds, then you could go after the sub. Well, the Supreme Court ruled a few years back that no, that you cannot do that. So keep that in mind, that the lack of privity can also work to your advantage as well. Can a subcontractor seek quantum merit from a general contractor? Oh, a subcontractor. Generally speaking, no. But there was a case that came down in 2014 that even surprised me, but it was extreme facts. When I'm talking about it, remember you have a owner, general contractor, subcontractor, subcontractor. For example, the owner is the owner, fair enough. The general, we get that. Subcontractor would be like the electrician. The subcontractor would many times be the material provider to the subcontractor electrician, who's contracted with the general contractor, who's then contracted with the owner. Can the subcontractor, who now has a subcontractor and might be out of business, go after the general? Generally speaking, that's also you can't for quantum merit. Generally speaking, no, but there was an extreme case, Zabo, where they were able to prove that the subcontractor took over the job. The general knew about it, and then even got paid from the owner for the subcontractor's work, and felt that it didn't have to pay the subcontractor. Now that's extreme, but I was out of the second district, and I knew the judge who did it, Judge French, and I had to give her kudos for, because generally speaking, when I first saw it, I go, that's just wrong. But when I read the facts, I'm like, that's a unique facts. So she did allow it, and she was upheld on the second district appellate court. And then actions taken by property owners to protect themselves. Now, keep in mind, I know this is a conversation about how to get paid, but in a way, that's also the negative. We have to know what to do if the owner does something to keep you from being paid. So these are all the traps that I have to bring to your attention, just in case. They can demand a Section 5 contractor's affidavit from you. If we all know what that is, it's like the Chicago title form that has like the name of the contractor, you or your subs, the description of the work, the amount of the contract, extras, credits or payments, the amount due for this payment, and the balance to become due. If you see all those like 5 or 6 columns, that is a requirement if the owner demands it. There was a split in the circuits again about 15 years ago where the first district said the owner has to demand it, then you have to provide it. And as long as you provide it once upon demanded, you have your lien rights. The second district once ruled then you don't even have to demand it. If you don't provide a contractor statement before you file suit, you are barred. But finally, they reversed themselves after much criticism that even the Section 5 talks about upon request or upon demand of the owner. So if you get a demand, you better provide it, and it better be under oath. Don't just sign it and what have you. It better be a sworn contractor statement with a notary. The leading case on that issue is actually one of mine, Wider versus Cams and what have you. So, but read Section 5. Then under Section 22, it has the same thing where for subcontractors, let's say a general sends a section 22 demand to a subcontractor, they also have to provide it. Otherwise, there's offenses that can be direct action against them as well for failure to provide it. So if you ever get something called a section 5 demand or a subcontractor section 22 demand, provide the contractor statement. Otherwise, you won't have your lien rights. Also, under the law, a property owner may also demand a final waiver from general contractor. Now, possession of a lien waiver from a general contractor is prima facie defense to a claim for mechanics lien. The law used to be that the owner had to prove they not only had the waiver, but that they relied on it by payment. Well, ironically, this court, which is ironically my case, which I actually lost, guys, and then went up the appellate court and they affirmed, they changed the law that said as long as they had it, that was enough. Basically, they didn't have to prove that they even relied on it in payment. So in essence, you then now have to do something called a 191 affidavit to force them to prove when they paid. Because I thought that was a little odd that a general contractor could give a waiver in the beginning, not even the sub is even hired yet, and that would be prima facie evidence that the general has already paid. I thought it was a little unusual of a decision, but that's the way the first district ruled. Now we have actions taken by property owners after perfection of a mechanics lien by contractors and subcontractors. I already talked about the section 34 demand here. That talks about how if you get something, you have to file suit within 30 days, and you have to name all the necessary parties within 30 days. It used to be, the decision just came down, it used to be that if you filed suit, but you didn't get all the necessary parties, but you did it before the 2 years was up, you were fine. Well, the court ruled recently that you have to have all the necessary parties within the 30 days. So let's say you didn't get, you did your track book search didn't come back fast enough and you filed suit thinking you had it right, and it turns out that you missed a mortgage company, you're going to get your lien claim knocked out. So if you get a section 34 demand, you have to move quickly. Talk to your lawyer quickly. Do not wait till the 27th day to contact them. Now, this is the part that I found interesting, is that if you have a arbitration provision in your contract, like as a general or an owner with the general or the subs, and you want to enforce it, but you do a section 34 demand under the Illinois concrete case, you waive your right to arbitration. I actually had a case where I was a little surprised because a lawyer that I have a lot of respect for, who gives a lot of seminars on mechanics liens and writes books on it, he did a section 34 demand against my client. I filed suit. Then he brought a motion to enforce arbitration, and he didn't know about this. And so I brought it to his attention, and he proceeded with litigation in court because he knew he was going to lose on that part. So keep that in mind. If you have an arbitration provision that you want enforced, do not do a section 34 demand. As basically the court said, you could have just simply sought arbitration to proceed and not do the section 34 demand, unless you don't care. Just so you know, I see arbitration provisions in contracts all the time. I still file suit. I would say about only 1 out of every 10 actually someone tries to enforce the arbitration provision. Then there's the section 34.5. This is brand new. I've never seen it used. But it actually allows the county recorder's office to adjudicate these liens. I got news for you guys. Mechanics Lien Act is a complicated act. It took me 3 years of working in it with it regularly just to get a working knowledge of the act. Now I've been doing it 26 years, but it's very difficult to learn. If you are a general contractor and someone tries to do section 34.5 through the recorder's office and you want to actually litigate this, if you file suit, of course, the judge takes over, a real judge, not an administrative law judge who might not have any familiarity with the Mechanics Lien Act. I would recommend that unless you know who the administrative law judge is, if he's familiar with it or she's familiar with it, fine. If not, get out of there and go to court. Then there's also section 35. This is the part that I just, so you know, I've nailed people with this twice now recently. If you get a section 34 demand and you don't file suit under section 35 demand, it basically says if you don't now provide a release of mechanics lien within 10 days, we're going to sue you for $2,500 plus attorney's fees in small claims court. And I've done this successfully many times. And for some reason, people fight it, and I don't know why, because it's pretty clear. And I believe I've won every time. I usually combine when I do it, or if I'm representing an owner, section 34, section 5, and section 35 demand in the same document, and I send it out, explaining it all out, what the rules are. And just recently I settled a case where I got $7,500 because there was 3 liens I had forced, or basically did section 35 demand for, and they didn't file suit. And so we settled for a lot less just from that reason alone. The general contractor could not successfully prosecute their lien claim. I would say 80% plus of my work is usually representing the contractor, but a good almost 20% is representing the owner. So I get a good knowledge of both, working knowledge of both sides. Then when I was talking about that new substitution of bond claim in there, that's the new law effective 2016. When this first came out and I had to deal with it, I called all my mechanics lien acquaintances or buddies, and nobody had dealt with it. I was the first one out of all of them. I've actually dealt with it 3 times now. It's very detail specific, but you have to file an application and get your lien claim. Now, what I've been seeing is sometimes people do all the work and they record a document of bonding substituting in the lien claim. That's not really enough. Now, it's putting a general contractor on notice or a subcontractor on notice when they file suit, but you still file suit the traditional way. Then you got to bring a petition to substitute the bond in. So I don't think there's anything wrong with people putting in as a bond and recording something to indicate to any other person's viewing title that there's a bond in lieu of mechanics lien, but that is not enough. The owner will have to actually petition the court, or general, if the general's trying to protect the owner, file a petition to substitute bond for a subject matter property. And there are a lot of requirements. I mean, look, a verified petition, that you have to include all these things. Now, there's some interesting stuff here about how you have to personally serve and if no objections waived, that type of stuff. And then you basically have to serve on all the parties in interest, and then you get a copy of an order, putting the substitute in, and then that has to be recorded as well. This is the part that I found interesting, is that, as you all know, the Mechanics Lien Act has an attorney fee provision in the Mechanics Lien Act, but it's hard to win. It says a kind of a vexatious and a reasonable refusal to pay thing for a contractor to obtain attorney's fees, or an owner, or the owner might get it if it's totally like an inflated lien or what have you, but it's extreme circumstances. Just because you win is not automatic. If you have a written contract that calls for attorney's fees and you substantially win, then it's pretty much automatic, as you know, subject to the judge, of course, but it's a lot easier to win in a contract action. Let's say you do not have a contract providing for attorney's fees. This is the part I found interesting. If the lien claimant wins at least 75%, claimant is a prevailing party, which would be, they might be entitled to get attorney's fees. If the lien claimant wins less than 25%, though, the principal of the bond, the applicant, usually the property owner or general contractor, is the prevailing party, and they could get attorney's fees possibly. So even though a contract action doesn't call for it, and it doesn't talk about the higher standard of vexatious unreasonableness, it could be automatic as long as you win a certain percentage or lose a certain percentage. If it's between 25 and 75%, no party is considered the prevailing party. That part was the part that I have to warn clients of, that, for example, if I'm representing the owner and there's no written contract requirement for attorney's fees, I warn them, well, under the bond claim, they might lose. Or if I'm representing the general contractor, if they don't win at least 25%, they might also lose, meaning lose and have to pay attorney's fees. So these are all interesting facts that I've had to litigate or deal with recently. And I've only seen it 3 times now. I've dealt with the bond claim, but I think that's more than a lot of the other attorneys so far. I am honored to be here speaking, everybody. I know these are 20 minutes. I do talk fast. I had to get quite a bit through all this stuff. I know it's been the 20 minutes. I am more than happy to answer questions. I'm not sure how that would work if you do it through Ariella. If she's gotten any questions, I'm more than happy to stick around and answer them.
So far, we
Ariella,
don't
but it's
have
been the
any
20 minutes.
questions.
I'm not sure what you want me to do at this time, but it's been my pleasure, everyone.
It's wonderful. You did a great job. If you want to go to the next screen, there is an area where there's all of his contact information. If you do have any questions, you can reach out to Patrick at any time. At the moment, we do not have any questions from our audience. But again, if you have any questions, feel free to reach out to us at any time. And Patrick, you did such a wonderful and thorough job Thank you for such a spectacular webinar. And I believe in our next slide, we have our next webinars that are going to be coming up. So if you wouldn't mind going to our next slide.
Oh.
Actually, you could take a moment to that's fine. You could keep it on this one. This is our next webinar. We have one in September 13th, which is don't sign that release unless it says this one thing. And everyone on this webinar knows how essential your waivers and releases. And the last one is getting paid faster with liens, bonds, and contracts in November. So again, Patrick, thank you so much. And I wish everyone a sunny day.
Thank you, everyone.